In today's video, we're going to talk about Florida's recent changes to tort law and the implications they have for your community associations. In March of 2023, Governor DeSantis signed into law HB 837. And with the signing of this law came sweeping changes to liability systems, statute of limitations, and it's important for community associations to understand how this will impact them legally, as well as how this will impact the operations of the association. One significant shift includes a presumption of liabilities in certain scenarios. Ultimately, this will alter the landscape of your negligence claims. So let me explain what comparative negligence was prior to this law being signed. So prior to being signed, imagine if you had a visitor in your community association and there was a floor wet sign, and unfortunately that person falls and gets hurt and files a claim. With the old language, even though the association had the caution wet floor sign, the association would still have some liability to bear if there was a lawsuit. So now let's give you the example with the new law and what changes have occurred. So using that same scenario, if it's determined that while the person was walking down the hallway and there was still that caution wet sign, that 50% or more was their negligence, then the association could be said that they're not liable for that particular claim. What the changes in the law highlight for community associations is the importance of having safety measures and having the right signages to help mitigate and reduce their exposure to liability. The second change is the shortened time for statute of limitation. So this shortened time does provide some benefits to our community associations. However, it's important that you keep in mind a couple things so that you don't find yourself in a difficult situation. So giving you a similar example to the previous example is, imagine if someone was hurt in an unfortunate incident with one of the association's elevators. In the previous law, that individual would have been able to have just about 4 years to be able to file a claim. With the shortened statute of limitation, it's been reduced down to 2 years. However, it's important to not take this shortened length of statute of limitations lightly, because it's important that you as an association are documenting what occurred and when it occurred. So it's important that if you don't have those protocols in place, that you're putting those protocols in place of what you're going to do if someone is injured at your community association. Number 3 is the modified premise liability law. So this is one of the most important, that I would say, in my opinion, of the changes that community association managers and community association boards need to have top of mind. So to give you an example of the changes here is, previously with the previous law, if there was a break-in, let's say in a condominium unit, and in an unfortunate circumstance, that person that's doing the break-in had an injury or something occurred, they would typically sue the association, and the association would have some kind of either joint liability, but they would potentially be impacted. However, with the new law, it changes to comparative negligence, and it also introduces the presumption against liability, basically allowing the association to reduce or completely eliminate its liability, assuming that it has the proper safety protocols or security measures in place. So this is why I think that this is very important for our associations to understand, because there are organizations that are coming in and detailing out for the associations what they need to do and what steps they should follow so that they can reduce that potential liability. I would also recommend our associations to keep top of mind that now that this law was passed, if you don't take these security measures, or you don't have someone come in and take a look at these things within your community association, identifying the signs, identifying where additional security or protocols need to be in place, then you could find yourself most likely in a much more difficult situation when it comes to these liability claims. If you're a self-managed community, or if you've never heard of this law, please feel free to reach out to us. We'll be more than happy to provide you with additional information. Further, we are working with partners that are certified in preparing these reports for your community association. If you've liked this video, please make sure to give us 2 thumbs up. Also, make sure you subscribe to our YouTube channel, as we have weekly videos coming out.